Hello everyone, welcome to our sixth lecture for NCA Constitutional Law. So today this is going to be one of the most important lecture because in this we will be discussing part 3 Aboriginal rights and the Constitution, and I'll be taking up all 5 topics mentioned in syllabus together because in examination there are chances that you get a question combined on these 5 topics related to indigenous people or aboriginal rights. So that is why it's important to discuss all these topics together in one go so that you can get an idea and relate one thing with the other. So now let's begin. So firstly, let's look into the syllabus. So this is part 3 of NCA Constitutional Law exam, focuses on aboriginal rights and the constitution. So students have to explore the unique legal framework, the structure, the sections, provisions that governs the rights of these indigenous people in Canada. Firstly, under introduction, we'll be talking about historical context and evolution of these rights, including importance of Section 35 as per 1982 Constitution Act. Then we will be talking about Aboriginal rights. And whenever in examination you are getting a question related to rights or title, after giving brief introduction, you will have to analyze the landmark cases that are mentioned in syllabus specifically. Like here for Aboriginal rights, we will be talking about R versus Sparrow, R versus Vanderpeet. And for Aboriginal title, which is based on the right to land, based on the historical occupation, use, landmark cases, Silcotin in Nation versus British Columbia. This is one of the most important case. Many times directly the facts of the question, the case scenario are based on these cases only. Then R versus Marshall again, treaty rights. Last topic is duty to consult. In this Haida Nation case is very important. When I wrote constitutional exam, I directly got 10 marks short question related to one of these cases. So this is really important. So before moving with the topic, firstly, I would like to give you brief introduction on the meaning of two important terms. So Aboriginal or indigenous, these terms are usually used simultaneously. So Aboriginal or indigenous, who are these people? Why are we using these terms? So these are the people who are original inhabitants of this Canadian land. So these were the people who were the original inhabitants, first people to occupy the title related to everything of Canadian land. So this include First Nation, then Inuits, Métis. So that we'll be talking about later, that who all comes under the definition of indigenous people. Sometimes we call them Indian also. So Indian does not mean people from India, like India the nation where we are from. So Indians, Aboriginal, indigenous, these terms are used synonymously simultaneously for these people who were original inhabitants of Canadian land. So traditional Aboriginal rights pertain to specific activities existing prior to European contact. When the European people came to Canada, they seized the land, they occupied the land, and then the British Crown controlled. We all know that history. So before European contact, the traditional, the original Aboriginal rights are the ones that we are talking about related to specific activities. So sometimes what happened in today's world, also in modern time also, there are many clashes when some people, some government authorities tries to construct some mining industry or tries to do something with related to the forest that comes under the indigenous people land. So they say that you cannot occupy this land, you have no right, or you firstly have to consult our nation's government, our nation's authority, then you can move further with these steps. So one cannot interfere with Aboriginal rights or their land. There are specific regulations because our Constitution of Canada directly protects these people. So their rights are directly protected under constitutional law. That is why they enjoy this special treatment. because they deserve this. This land belonged to these people originally. So treaty rights derive from activities stipulated in treaties. So they made few agreements with the governments after the Britishers came to Canada. They controlled the whole nation. So they involved in few agreements, and based on those agreements, which we call treaty, few rights came into existence. So many times these rights are in question. These rights become the main point of issue in various case laws, so that we will be discussing side by side. So aboriginal title relates directly to land, encompassing its occupation, possession and use. How one can use aboriginal land, or to what extent, or are we allowed to interfere into aboriginal land or not. So aboriginal rights, treaty rights, aboriginal rights are simply related to the activities that aboriginal people used to do on their land prior to European contact. So there should not be anything new. So the rights that are protected are the ones that were kind of a customary rights that they have been performing before European contact. So treaty rights are something that arises from the agreements that came into existence between these aboriginal governments and the modern government, the British government. Then thirdly, aboriginal title. So these three things are in question, relates directly to the land. So land means what kind of occupation, what occupations aboriginal people are allowed to do. Then possession and usage. So federal jurisdiction over aboriginals. Firstly, we'll be talking about this thing. So who controls right now in today's world? So section 9124 says that federal government has jurisdiction over indigenous people and lands reserved for them, but there are few conditions. So for that we will be going to section 35(2) later on, and the Indian Act. But as per 1867 Constitution Act 9124, it directly says that indigenous people and their lands both are subject matter of federal government. So provincial government has no control. So in examination, if you get a question related to division of power and something is related to aboriginal or indigenous people, one thing is clear there and then, that there is no role of provincial government. So this grant of jurisdiction facilitated the imposition of uniform policy across all indigenous groups throughout Canada. So the federal government is controlling. That is why, what do we mean by this? That there are no different province-wise rules and regulation. So everything is uniformly controlled. Government enforced policies like residential school aimed at eradicating indigenous culture, assimilating indigenous children into Eurocentric norm. Then legal avenues for indigenous land claim were obstructed by federal legislation. They prevent indigenous people from pursuing justice in court. So section 9124 also extend federal authority over lands that are designated for indigenous use, including areas reserved under royal proclamation and those under aboriginal title. So federal authority has jurisdiction over all these things related to indigenous people, aboriginal people. So who all comes under the definition, the term, the word Indian? So initially all indigenous people in Canada, they came under this. Now aligning with the parameters outlined in section 35(2). So Indian Act govern indigenous affair employing a band system. So basically a group system, a band head was there who used to control the status and rights, determine the status and right of people. Then later on, when constitution came into existence, federal jurisdiction extended over these land as per 9124. So federal jurisdiction extend to land reserved for indigenous use, including those held under aboriginal title, granting exclusive authority for agreement, land dispute resolution, negotiation related to indigenous land. So whenever there is a dispute, so the one party would be federal government, if that is the party who is infringing, because no other authority has right to infringe, right to interfere in these kind of things related to aboriginal people. So section 35 gives definition. It says that First Nation people, then Inuits and Metis. These are the three people that comes under. So section 35 of Constitution Act 1982, whenever in examination you are getting a question related to rights of indigenous people, the first thing that you have to mention under the rules is this section. So without this section, your question is incomplete, or rather I would say it's of no use. Section 35(1) recognize, affirm, provides us that Aboriginal treaty rights do exist and we have to respect them, follow them. Fiduciary duty to safeguard indigenous interest and promote reconciliation effort. So now, one thing that I told you, that section 9124, under this only federal government has authority. Over any matter, only federal government can legislate on matter related to indigenous people, even those which are related to a provincial jurisdiction like education. So no matter whether education comes under provincial jurisdiction, if it is related to indigenous people, it will be governed by federal law. But here, important thing that comes into existence is that whenever federal government has to use section 9124 power to enact a law related to aboriginal people, related to indigenous people, they have to work with section 35(1) and 2, because section 35(2) limits the power. So they say that section 35(2) says that whenever federal law is enacting anything related to indigenous people, they have to follow these two sections. And one thing is that we have only given federal government authority to safeguard aboriginal rights. So the authority here is not just to make law, whatever federal government wants to. No, there's a big no. Keep this thing in mind. Whatever law federal government is making, that is just a responsibility given to the federal government to protect aboriginal and treaty rights. So what does this mean? This means that the people, First Nation, Inuit, Métis, the three category of people that I have talked about earlier, and those are mentioned in the 35(2). So whenever any matter related to these three category of aboriginal people, section 9124 says that federal government will make law only to recognize and affirm existing treaty rights. So federal government cannot make any law to remove aboriginal or treaty right, cannot make any law that is against the indigenous interest, or that is against the promotion of reconciliation effort, or that is something to segregate indigenous people from other people of Canada, or something that is not in the basic interest of indigenous people. So I hope one thing is clear here, that section 35 says that whatever power we have given to federal government has to perform a fiduciary duty here. Fiduciary means a duty of trust. So we are allowing federal government under 9124 because indigenous people trust that. They have this trust in the federal government that they will work towards the best interest of indigenous people. But in case federal government does something that is against aboriginal treaty rights, that is against indigenous interests, then that thing will come up before the court, and for that we will be discussing various case law, that what kind of issues come before the court. So in Daniel versus Canada, Supreme Court affirmed that non-status Indian could be considered Indian under section 9124 with determination based on individual circumstances. So in some cases, few non-status Indians who are not Métis, Inuits or First Nation, sometimes they also considered as indigenous, but it depends upon case to case individual circumstances. So this means that this definition of Indian is progressive, not restrictive. Provincial jurisdiction over Aboriginal. So this thing has been made clear that provinces cannot legislate related to Aboriginal treaty rights, but they can only legislate if there is some kind of subject matter that is within their enumerated power, like directly comes under section 92. So legislation affecting indigenous people must have an incidental direct effect laws directly targeting indigenous community fall outside provincial jurisdiction. So this thing you have to keep in mind. So usually what's the general rule? That only federal government, but if there is something that is under the enumerator part, so you have to go to section 92 and see that whether this particular thing comes under section 92. If yes, then they can, but if no, then they cannot. Then only federal government can make law on that matter. So these were the general rules that we talked about, that federal government can make law related to indigenous rights, treaties, but there are 5 exemptions, 5 exceptions to these general rules. First is singling out. So this render invalid any provincial law that purposes single out Indian. So we read that under section 92, if something is directly mentioned on that matter related to indigenous people, provincial government have right to enact a law, provided that law should not be something that separate out, segregate, single out Indians from that province. Second thing is Indianness. So if something is going to the very basic nature, the true Indianness, like being indigenous, aboriginal, so if something is going to that, so that kind of law is also prevented, cannot make, so province cannot pass any legislation that impair the original status, capacity of aboriginal, or that limits an aboriginal right. Third is paramountcy. So as I told you earlier, that general rule is that federal law will enact. So if a federal law and provincial law regulating the same subject matter, the federal law will take precedence as per paramountcy related to indigenous law. Then National Resources Transfer Agreement. Agreement between federal government and Alberta, Saskatchewan, Manitoba. They transfer the control of natural resources to these provinces. So these 3 provinces. This changes the level of government that has control of natural resource from federal government to provincial. So automatically if something related to natural resources and something related to indigenous and natural resources is related to these 3 provinces, then there, because we already have a valid agreement that share power, that transfer power from federal to the provincial of these 3 provinces, then in that case, provincial government has the power to control natural resources. Then Section 35, 1982, Aboriginal rights are hereby recognized and affirmed. The guarantee of Aboriginal right has imposed a burden on both level of government. Unless the province is able to justify an infringement by the test in R versus Sparrow, law will be unconstitutional. So province cannot justify law that infringes the rights of Aboriginal people, because Section 35 directly puts a burden that both level of government have to, on the basis of fiduciary relationship, protect Aboriginal right and title. But in R versus Sparrow, we have a legal test that says that if few things get fulfilled, then it is justified for a province in these and these circumstances to go beyond the protected rights for indigenous people, then that would be unconstitutional. Otherwise, it would be unconstitutional. So what is R versus Sparrow? That we will be talking later in this lecture in detail. Next is Royal Proclamation of 1763. So following the British-French conflict in North America, proclamation acknowledged Aboriginal title and established principle for land management. So this proclamation prohibited private land sale, established the surrender, the giving up processes, and asserted imperial control over settlement. While this is not relevant today, its principles continue in Canadian jurisprudence, ensuring rights for indigenous group. So Royal Proclamation also some way talks about the surety for indigenous right. So this was the basic introduction. Now the main topic is Aboriginal rights. Firstly, we'll talk about what do we mean by Aboriginal rights. In examination, again, I am saying if you're getting a question related to Aboriginal right, first thing that you will have to do, by which you will be starting your analysis. So after rules, in rule you are going to mention section 35, 1, 2, then if it's related to division of power, then you can mention 91, 24, 92 also. Then next thing, when you start your analysis, first thing is you have to mention in brief, like in 3-4 lines, what are Aboriginal rights. So let's read. So Aboriginal rights stand as a distinct, different category within legal framework categorized by their unique nature application. We know that Aboriginal rights are only related to Aboriginal people. But there is no one size fits all definition. Aboriginal rights, what are those? These depends upon case to case basis, various historical, cultural, legal context influences. Each Aboriginal right is inherently different from another. Because we know that Aboriginal people themselves have different culture, different tradition, histories across different region and community. So in the forthcoming chapters, we will delve deeper into the intricacies of these rights. We will explore their origin, form, implication. But here you have to understand what are Aboriginal rights. So these are rights inherently. They got these rights in inheritance, tied to the historical reality that indigenous people. So where these rights are coming from? These rights are coming from the concept, the reality that once autonomous self-governing entities means no control by any other government over majority of land that now comprise Canada. So once these people were the real occupant of this whole Canadian land. So these rights are rooted in the fundamental principle that indigenous community had established system of governance. So they had their own way of living, own way of governance, own way of stewardship long before European colonization. So before Britishers came, they started colonization. So they had their own way of living, and this was nothing like for 1 year or 2 year. This was from thousands of years. So they deserve a special affirmation, special acceptance. That is why we are recognizing today Aboriginal rights and their title. So R versus Sparrow, this is landmark case related to Aboriginal rights. Supreme Court provided a definition of what an existing right is and laid out the test for determining what an Aboriginal right is and whether a right has been interfered with by the government. So section 35(1) says all pre-existing rights, whatsoever rights were existed before European colonization, are hereby recognized and affirmed. Court said existing means unextinguished, which are not extinguished, which are still exercisable. They say that existing suggests those rights are affirmed in a contemporary form. Existing rights that were existing in 1982. So these are the few things that you have to keep in mind. So it means the rights were not given up till 1982. Did it create rights that did not exist prior to 1982. So the rights that were not existed before 1982, those rights are not protected. Only indigenous rights that were there were successfully followed, enjoyed by indigenous people till Constitution Act 1982. So those rights are validly protected. So there is a four-part test that sets out whether or not there was aboriginal right and whether the right was infringed by the government. So is there an existing aboriginal right? First, you have to answer this question. Existing means 1982. Has the right been extinguished or the right has been extinguished, no more in use? So yes, test ends here. No aboriginal right to infringe. If this says that the right has been extinguished, so the test ends here. But if the right has not been extinguished, then thirdly you will have to check right has been interfered with by the state, by the government. Is government trying to interfere with that right? Last is, can the government justify that infringement? So in examination also you will have to follow this kind of step only. So these kind of four steps you have to follow in examination when you are analyzing a question on aboriginal right. So what were the facts? So in this case, Sparrow was charged under Fishery Act for fishing with drift net, which were no longer permitted by terms of banned fishing license. Sparrow considered that he used a net that was in violation to his license, but argued that he had an aboriginal right to fish and that his use of net was an extension of aboriginal right. So Sparrow said that this is my aboriginal right to fish. This was how I have been fishing throughout. So Crown said that the Fishery Act has extinguished this right. So question is, was there an infringement on his aboriginal right and was it justified? So court held that he had an aboriginal right to fish under section 35(1), and the Crown here, Crown Council, that is representing on behalf of the state, has confused regulation with extinguishment. Regulation cannot extinguish an aboriginal right. So they say that the court held that any law, any regulation cannot extinguish an existing aboriginal right. So if the government wished to extinguish a right through regulation, the state would prove a clear and plain intention to do so. You cannot make a confusing, a derogatory act that is against the interest of Aboriginal people. There cannot be any partial extinguishment. They should be clear and complete. So is there an Aboriginal right? Yes. Has it been extinguished in this case? No, it was existing. Regulation does not extinguish an Aboriginal right. Is there state interference? So court looks at whether the legislation or regulation is unreasonable, cause undue hardship to the people. So here they saw that whether the regulation has created any hardship for sparrow. Can the state justify this interference? So in this case, the court did not have to analyze whether the infringement was justified because Crown put no arguments that was justified. So regardless, the court provided factor that would be considered in determining whether an infringement was justified. So court would look at whether the government has valid reason for interfering in such right, whether there has been any safeguard or consideration of aboriginal right of question. So whether in achieving a valid objective there was minimal, least interference with that particular aboriginal right. So whether any fair compensation was given to that person or not, whosoever's right was infringed. So whether government consulted before making that legislation with the aboriginal head, aboriginal crew. So there can be valid justification for infringing aboriginal right if the justification is sufficiently defined. It's clear cut. There has been a consultation prior to making that legislation, law, any policy that is interfering with aboriginal people. So if there was consultation and the aboriginal head themselves said that okay, this is, we are fine with this, you can continue with this change, then there is no question. So regulating fishing in the public interest would be too vague to justify the infringement, but it was considered for conservation and resource management that could be valid justification depending upon the facts. So here there was no clear-cut answer, but the court cleared out one thing, that if these things, these last 4 or 5 things are achieved, then the state, the government can say that there was a valid interference. But if these things are not fulfilled, then there is no valid interference and it is unconstitutional. The government has to take back that decision. Another case, R versus Vanderpeet. So this further expanded the text for the existence of aboriginal right. So at para 46, in order to be an aboriginal right, an activity must be an element of practice. As I told you earlier when we were talking about the definition of aboriginal right, that's something that is customary in nature, traditional, and important to distinctive culture of aboriginal group claiming the right. So the right that they are saying is in question is something that is in the core of aboriginal people, so that they have been following as a part of their culture, as a part of their tradition. At para 55, the practice, custom, tradition was one of the things that made their culture socially distinctive. Definition provided above was crucial for step 1 of the test in Sparrow. So this one. Distinctive does not mean it is unique to one culture. It means a part of the society, means important, integral part of the culture. It should not be something incidental. It should be directly important to that particular aboriginal group. So what does it mean to be integral? So activity must be one of the central significance to aboriginal community, one of the defining characteristics without which they say that the right that they have been enjoying since time immemorial is getting infringed now and is providing them harm. So right must have existed prior to European contact. There is no doubt in this. As per section 35(1), then the right must be integral part of their community. So test in Sparrow only applied to traditional aboriginal right. So it did not apply to treaty rights or not to aboriginal title. But here in R versus Vander P, the meaning of aboriginal right, what all other things can come under this definition, was brought before court. So what were the facts of this case? Van was charged under Fisheries Act for selling fish caught under the authority of food fish license after she had sold 10 salmon not for profit but for the support of herself and family. So not for business purpose but just for family purpose. So Van argued that she had an aboriginal right to catch fish. Her culture caught fish for food and ceremonial purposes, and this is integral to culture. So court held that right to fish for food and ceremonial purpose did not include right to sell fish. So using fish for own purpose does not mean that you are selling, even if it is for support of family or herself. Any tradition of family by band was incidental to their culture. The court narrowly defined what would be considered an aboriginal right. How does the court decide was integral and incidental? So the trial judge seemed to expect that historically the band used to trade fish, but they did so incidentally. It seems to be a requirement that there seems to be a level of frequency for an activity to be integral. So there should be some kind of continuity, a habitual thing, a customary, a traditional thing that has been followed throughout. So Christians only celebrate Easter and Christmas once a year. Does that mean it is not integral? So this was the criticism to this trial judge reasoning. So her aboriginal right was protected up until the point she started to sell the fish. So if she only caught fish and she did not sell, just ate herself or her family, then there was no question related to aboriginal right. But if she's further selling the fish, even for family, that includes business profit, so that is banned. She was then fishing for commercial gain, so that was no longer protected by aboriginal right. So court said that any ambiguity in section 35(1) should be resolved in favor of aboriginal. But here what court said at the end, that if there is some kind of confusion that is leading court not to bring into one particular decision, then the decision will be in the favor of aboriginal. So remember, the right has to be established prior to European contact. While it can evolve, it cannot stretch to new activity. So right to fish with a spear has now evolved to right to fish on a boat. This is not a issue, but the right has not changed to right to hunt. So you can just change the kind with which you are following that right, but you cannot add on other things with that particular right, because we know that in modern world, like in previous times, the fishing was done with a spear, now the fishing is done on boat. So this is valid, this is justified, no issue with that, because time has changed, things have changed. But it does not mean you can add on other things with one right, so that won't be protected. Then R versus Paule, two First Nation claimed the right and Aboriginal right to hunt for food. So hunting for food, just for food. Supreme Court held that distinct First Nation community had settled in the community and that it had a distinct cultural society that existed prior to European control. The court concluded that settlers had taken control of the area around 1850. So First Nation community in that area existed prior to this time, prior to European contact. Further demonstrated that hunting for food was always an integral part of this community even before European contact. Court used the time that Europeans took control as the relevant time frame for First Nation claiming a right. Van test has been slightly altered for the First Nation. When they are claiming an aboriginal right, the person must show the activity is a practice, custom, integral part, that the practice must have existed prior to European contact. Unlike Van test does not mean there was a European contact. It means they took full control. This time will vary from case to case. So, because Europeans did not took control all over the Canada at one point of time. So, it will depend from case to case. We are not here talking about any particular date. In this case, there had been contact with European before 1850 but did not take control until then. Therefore, 1850 was used a date a right had to be existing from to be protected. So this was the date. In this case, a particular thing came up. So here we are not talking about any aboriginal right that we already talked about in previous two cases. Here we are talking about which date. What do we mean by European contact, European control? So in examination, if you are getting a case scenario, a question related to European contact specifically, then there you will have to follow this case. Next is who is a First Nation. So firstly, self-identification. Person has to consider themselves as a First Nation. Then there should be some kind of ancestry connection. Community acceptance. This has been questioned by Supreme Court in Daniel versus Canada. Court said that three factors were more a framework than a hard test. The first two needs to be satisfied, but third, community acceptance is not a requirement. Because even if a person is rejected from their community, it should not strip them from the protection under section 35(1). So these first two things are important for a person to be treated as of a First Nation. Now, the question is, these aboriginal rights, are these immortal or can they get extinguished? So extinguishment of aboriginal rights. First is surrender. So extinguishment can happen if indigenous people voluntarily, without any force, surrenders their rights to crown. So this surrender must be consensual, typically involve negotiation, agreement, like we say treaties between indigenous community and government authority. Second is constitutional amendment. Extinguishment through constitutional amendment required changes to legal framework that govern this aboriginal right. In such cases, there is a fiduciary duty on part of government to firstly involve the affected indigenous people whose rights are in question, they are getting extinguished. Then, before making constitutional amendment, they have to consult all those people. So this duty reflects the obligation, the mandatory nature, the compulsion to act in best interest of indigenous people and to respect their rights and interests. So these are the basically two ways in which we usually extinguish the aboriginal right. So first is surrender, second is amendment. Next topic is aboriginal title. So concept of aboriginal self-government gained recognition through various legal political agreement. During the Charlottetown Accord, all first ministers acknowledged the inherent rights of indigenous people to self-government, that they were governed by their own band authorities, by their own governments. So when these accords ratified, these rights then transferred to 1982 Constitution Act under section 35. Delgamuke versus British Columbia. In this case, indigenous plaintiffs sought a declaration of aboriginal title and self-government right over specific territory. While the court refrained from directly addressing the claim of self-government right, they emphasized that aboriginal title is held communally. So there must be internal structure for communal decision making, that this aboriginal title is nothing individual, this is affecting a whole community. So what is an aboriginal title? This is the right to exclusive occupation of land where indigenous people live, granting indigenous people authority over the land that they traditionally occupied. So this right can extend to land where indigenous community may not have formal title recognition, but they have been traditionally living. So what do we mean by aboriginal title? So we already studied about aboriginal rights. We are clear on that thing. So those are the specific things that have been performed by indigenous people over a period of time. So aboriginal title is specifically related to occupation, possession of land. So fundamental right granting indigenous community exclusive. So this is exclusive occupation and possession of land itself. This encompasses not only rights, so right comes into aboriginal title. So aboriginal title is a wider thing. The right comes under the title. So this is a part of title to inhabit the land. So right to inhabit the land basically is under aboriginal title. Also the authority to utilize, to use that land which is inhabited by aboriginal people for different purposes beyond those traditionally associated with indigenous activity. So under Aboriginal rights, we talked about those rights that were traditionally performed by indigenous people before European contact. You have to keep this thing in mind. Here we are not talking about traditionally associated things. We are saying that there is a land and Aboriginal people can use it in whatever way they want to. So this Aboriginal title is protected under Section 35. Aboriginal title bestows upon indigenous group ownership of land. So they are the owners of that land, secure their inherent connection to and stewardship over it. Crucially, establishing an interest in the land must occur prior to assertion of sovereignty by colonial power. So again, this is important. European contact is important here, but here we are not talking about something that has been till date in similar form. So we are saying that only interest, like the rights we talked about earlier, only the interest in the land should occur prior to European contact, but today they can use it in whatever way they want to because they are the real owners of that land. So this recognition underscored the historical and cultural significance of indigenous land tenure rooted in pre-colonial occupation usage pattern. So what are the key points that are related to Aboriginal title? So this was held in Delgamuk versus BC. Aboriginal title will be established where land was occupied prior to sovereignty. Aboriginal group maintains a substantial connect to the land. So they were living on that land. They had exclusive possession of that land even before Europeans came. So establish the test for determining if Aboriginal title exists. Trial judge dismissed all the land claim. He said since BC entered into confederation, the province had unburdened exclusive title, unburdened to all soil in the province. He did acknowledge that provincial crown has fiduciary obligation, but he said the obligation was limited. But later, this trial judge decision was in question before the Supreme Court of Canada. They provided the test for Aboriginal title. So they say that in order to prove Aboriginal title, it must be established, it must be demonstrated that there was particular occupation and possession. It is not necessary that occupation was broken or possession be exclusive. So all Aboriginal group needs to do is show that they had substantial maintenance of occupation. So they have to show some continuity. It is not that 50 years ago you were living there, now after 50 years you are claiming that land. So that won't be possible. That does not help you in getting the Aboriginal title. You have to show some kind of continuity. So this continuity thing is important. So step 1, is there an existing Aboriginal title? So firstly, continuity, important. Then exclusive possession, you have to show sufficiency of occupation. What does this mean? So this is new term. This means that the group, Aboriginal group, must show it communicated to others they held the land for its own purpose. That everyone around should know that this particular land has been occupied by Aboriginal people. Second step, has the right been extinguished? So if in 1982 any right related to that occupation of land related to Aboriginal title expressly extinguished, like someone gave up, then later on you cannot say that okay, I want this title back. So that won't be possible. Right has to exist and then only it can be protected by section 35. Then Crown cannot extinguish an existing Aboriginal right without clear plain intention to do so. So Crown has to clear forward say, like we read in the previous cases of R versus Vanderpeet Sparrow. So then Aboriginal right has to be clearly extinguished by Crown. Crown cannot make any confusing legislation. Is there infringement of right by state owners on Aboriginal group to prove? So, is the legislation unreasonable? Has it caused undue hardship? So, all those things that we discussed earlier under Aboriginal right again comes into question here. Because Aboriginal title is nothing, just a more wider right occupied by Aboriginal people related to land. Did it deny group the preferred means of exercise right? So this denial has to be shown that it caused some kind of harm, interference, Can the state justify the infringement? So all those steps are repeating again here that we discussed in previous cases under aboriginal right. So valid objective, valid justification has to be shown. Then whether there has been any consideration of aboriginal right, or whether they have been discussed with aboriginal people, or whether there has been minimal interference, fair compensation was provided, whether government consulted. So duty to consult comes into picture again, because Crown has a duty to consult regardless of the nature of infringement. No matter infringement is small or large, you have to discuss before bringing any change related to aboriginal right or title. So this is very important, and particular change must be undertaken in good faith with the intention to listen to the concerns of the aboriginal. If you are discussing, if you are sitting in a negotiation setup with aboriginal people, it doesn't mean that you can just force your thing, force your decision. You have to accommodate their interest, you have to listen to what they want. So this was aboriginal title. Now sometimes students get confused between what is non-aboriginal title, because sometimes in a case scenario you firstly have to see whether aboriginal title is in question or not. There you firstly should understand what is an aboriginal title and why it is different from non-aboriginal title. So for that you will have to see the source of title, where it is coming from. So aboriginal title is derived from pre-sovereignty, pre-European contact by indigenous people. Non-aboriginal titles simply comes from crown grant. Then range of usage. Aboriginal title allow for land use that is not irreconcilable with the nature of attachment to land, reflecting indigenous culture and traditional practices. Then aboriginal title is inseparable, cannot be transferred directly to third party. Communal ownership. Aboriginal title is held community by a group of people, not by a single individual. So cannot be owned by individually by an Aboriginal person. So in examination, if you're getting a question and there is just one person who is claiming Aboriginal title, there and then you can in your analysis mention that this is not an Aboriginal title. This could be a right, but not an Aboriginal title. Constitutional protection. So aboriginal title is constitutionally protected. The rights associated with it cannot be extinguished solely by any kind of legislation, be it provincial, federal. Any attempt to do so would conflict with federal jurisdiction over Indian and land reserved for them. So provincial law can never extinguish any aboriginal title. If federal government is doing so, so federal government can, but within the limits of law, within section 35, by accommodating the interest of aboriginal people after consultation. So duty to consult is must. Then there is another landmark case on this aboriginal title. So Silcotin Nation versus British Columbia Minister of Forest. Very, very important. So this nation, a collective of 6 bands sharing common culture, history, have inhabited in a remote valley in central BC for centuries. So they were living there for hundreds of years, and that land was surrounded by river and mountain. They are among hundred of indigenous people in BC with unresolved land claim. So their land claim was unresolved, disputed. In 1983, BC granted commercial logging license on this land, which was disputed by this nation. Band objected and sought to prohibit commercial logging. Talks with the province stalled, leading to an amended land claim, including a request for aboriginal title. So both federal and provincial governments opposed this title claim. Supreme Court of British Columbia found that Tilcotin Inn had established occupation for proving title both within and outside claimed area. So British Columbia Court of Appeal applied a narrower test, concluding that they had not proven their title. So appeal should be allowed, granting a declaration of aboriginal title over the requested. So here one thing we know, that the province BC breached its duty to consult the Silcotin and must be declared. Silcotin established aboriginal title to claimed area, so whosoever claims, the burden of proof is on the claimant only, on that person. Aboriginal title derives from regular exclusive land use, sufficient occupation must be continuous. So trial judge applied all these correct legal tests. So province criticism on judge finding lack merit. This justification requires a compelling governmental objective compliance with fiduciary duty to the Aboriginal people. So here province failed to consolidate and accommodate the Silcotin. Provincial forestry legislation no longer applies once Aboriginal title is recognized. So this is important because provincial regulation applies to Aboriginal title lands subject to Section 35 framework. So Section 35 balance the Aboriginal right with effective regulation. So in this case, province forestry authorizations were inconsistent with their duty to Tilcotin people. So this is important. So that is why the duty to consult here got breached and Silcotin successfully established their Aboriginal title. Now next topic is treaty right. So agreements. Treaty means agreement. What kind of agreement? So these agreements were inked between indigenous people and settlers and British Crown. So when delving into Aboriginal right, the spoken word often carries more weight than the written script. So this is the thing that we are not always here to go by the written things when it comes to Aboriginal right, because their rights, their interests are the most important thing that we have to protect. But still we have few written scripts in the form of treaty rights. So they hold a unique status termed sui generis. So sui generis means something which is unique in nature. So this was held in Simon versus the Queen. In this case, it was held that these treaty rights hold some unique status. So Aboriginal treaties embody three defining characters. So what are the three things that needs to be there in an Aboriginal treaty? So number one, this treaty must have been came into existence to build some legal relation. Then there must be presence of mutually binding obligation. So the things that have been concluded in this treaty, both the parties, like the British Crown as well as indigenous people, are bound by those rules. Whatever has been concluded, whatever has been mentioned in the agreement, after they have signed this treaty, then they both have to go by that only. Then a certain solemnity attached to the agreement. Solemnity means something serious. So this treaty has to be taken serious and with dignity. Crucially, these arguments are legally enforceable. These agreements, sorry, are legally enforceable. If someone breaches any treaty provisions, then you can bring forth that thing before the court of law. Honor of Crown is perpetually on the line in dealing with indigenous community. It is presumed that Crown is committed to uphold its pledge that whatever promise a Crown has made in these treaties, the Crown will follow that. When it comes to Aboriginal treaty, burden of proving their extinguishment lies squarely on the Crown's shoulder because these treaties were mainly the intention, the requirement on part of British Crown. So Section 35 provide protection of treaty right and encompass rights acquired through modern land claim agreement. Consequently, any new land claim agreement gain constitutional status upon signing. They entail an agreement between Crown and Aboriginal nation marked by mutual obligation, authority to bind principle, intent to create legal obligation, consideration and formality. So this is the main definition, meaning of treaty rights. So they create particular legal rights. So how do we interpret? How do we understand whatever is mentioned in the treaty? So we give liberal interpretation to treaty, resolve doubtful expression in favor of indigenous people. So whenever something is confusing the court is not able to decide or able to take decision in favor of one party. Then always doubtful expressions leads to favor indigenous people. So whatever is favored for the indigenous people, the court will take that decision. This approach stems from historical disparity in bargaining power, discrepancy between oral understanding, written record. Moreover, it's now established that Crown bears a duty of trust, fiduciary duty, ensuring fairness in new agreement. However, it's uncertain if same kind of interpretive method applies uniformly to new agreement. So this we are talking about the older treaties because there when these treaties came into existence like 50-60 years ago or even before that, then we are not sure how much clear records have been maintained, because then at that time there were few language barriers also between indigenous people and British crown, so we are not sure who was at the bargaining power, who was at the superior authoritative power. So that is why we always favor indigenous people whenever there is some doubtful expression related to old treaty rights. Then treaty rights can be extinguished exactly similar to aboriginal rights through voluntary surrender and constitutional amendment. So exactly two methods, surrender and amendment. Then application outside charter rights. So section 35 enjoys advantages outside the charter. It's not qualified by section 1. So whenever we talk about any other charter right, any other constitutional right, we know that a state is justified in doing something against those constitutional provisions if particular action of government of state is valid or justified under section 1. But these section 5 aboriginal rights, treaty rights have been kept outside the charter. Also, section 35 can never be overridden by section 33. So this is the unique status. Why we call unique? Because section 35 has specifically inserted into the Constitution Act to give a special power, to give special protection, affirmation to Aboriginal rights. So these Aboriginal rights are neither applicable for section 1 Oakes test nor can be overridden by section 33. So these are unique, these hold unique status. It defined Aboriginal people of Canada broadly, including status, non-status Indian. But section 35 rights aren't absolute. So this we see in R versus Sparrow. So they can be justified if the government is doing something with an objective, justified, reasonable objective, compelling, substantial, such as conserving a limited resource. So there are some natural resources, limited resources. So government is doing something on the indigenous land, or government has to infringe or interfere in the indigenous rights, aboriginal rights to some extent, to the extent of this protection of limited resource only. So there, if the government is providing proper reasonable justification that okay, this is our objective, then only section 35 rights can be interfered with, otherwise no. So section 1 has no application here. Here we are only talking about Sparrow test justification. What are the rules, 4-5 steps that have been included in R versus Sparrow? We have to follow those. If all those steps are fulfilled, government is justified and is pursuing an objective deemed compelling, substantial, then the rights of section 35 can be interfered with. So this is the only one area, Sparrow justification test, which we follow for aboriginal rights. So for aboriginal rights, again I am clarifying, we do not apply section 1. Application to treaty right. So Budget 1996 established that Sparrow's doctrine applies to treaty rights also. Sparrow justification extends to both aboriginal and treaty right. Then Sparrow implies that section 35 protect aboriginal treaty right from extinguishment by federal legislation. However, such rights can only be extinguished through surrender or constitutional amendment. So these are the two ways through which we extinguish the treaty rights. Then it's unclear if section 35 provide absolute protection against the provincial laws, or if infringement is permissible under Sparrow test. So Sparrow test only clarifies the federal government's position, it does not clarify the provincial laws. So this you have to keep in mind. Then we have important case R versus Marshall. There are two cases related to this. Firstly, the judgment came in 1999. So in this, Miakem Indian faced charges under federal fisheries regulation for selling eels without license, fishing without license, using illegal nets during the close season. Trial focused on whether the accused possessed treaty right that exempted him from complying the regulation, the rules. So during the treaty negotiation of 1760-61, Aboriginal requested truck houses in exchange for their peltry. Document, however, only restricted Maycomb trading to appointed or established truck houses. So trial judge interpreted this as granting Maycomb the right to bring their products to trade at a truck house. Court of Appeal upheld thus conviction, reasoning that trade clause didn't grant the Maycomb right but served to maintain peace with the British. So this is important. So what was the issue before Supreme Court of Canada? Whether the accused possessed treaty right exempting him from the regulation. So appeal should be allowed and acquittal entered on all charges. So here acquittal entered. So person was released. So Court of Appeal erred, failed in rejecting the use of extrinsic evidence when interpreting the treaty. Extrinsic evidence, even in modern context, can show that a written document does not encompass all agreement terms. So there could be something that are not applicable in today's modern world. Historical control context can be considered even if treaty documents appear comprehensive. So we have to look back that at what time this treaty came into existence, and at that point of time what was the scenario, why this particular thing had been including, what was the intention behind that. So we have to go back to that time. It would be unconscionable for the Crown to ignore oral term while relying on written one. The treaty entitlement extended beyond the right to bring product to truck house, while the treaties imposed a restrictive covenant. They didn't contain all promises made. So treaties had not all promises in written form. So there were few things that were said by orally, by words. So that is why we always, whenever there is some confusion, give decision in the favor of Aboriginal people. So upholding Crown's honor integrity required considering the content of treaty promises, interpreting the treaty arrangement to negate, make him right, contradict the Crown integrity. So accused didn't need to prove preferential trading right, only treaty trading rights were more than enough here to justify their position. So when 1982 Constitution Act came into existence, the Meerkim rights weren't less than those of other inhabitants unless previously extinguished. So these were not extinguished. These were still valid when this act came into existence. So accused caught and sold eel for sustenance, exercising his treaty right to fish and trade. So this was valid right that was being performed by the accused. So enforcement of the closed season and discretionary licensing interfered with this treaty right. So these particular regulations interfered with this treaty right. Without justification for regulatory prohibition, the accused was entitled to an acquittal. Then in 2005, again in furtherance to this, case came up before the court, R versus Bernard and R versus Marshall 2005. M and 34 others in the band were charged with cutting down trees in Nova Scotia land without a permit. B also in land was charged for being possession with 23 logs from the cutting site. Does the truck house clause that support right to fish support the right to log commercially for moderate livelihood? So in furtherance to the previous Marshall Act, this issue came into existence. They and built house, sled, snowshoes and did engage in occasional trade of wood product. Purpose of this activity was to sustain themselves, not to trade. So the Aboriginal people did all these activities for their sustenance, for their basic livelihood. Supreme Court held that the truck house clause here, which supported right to fish, did not confer a modern right to engage in commercial logging. The right conferred is the right to trade. So only the trading activities that were contemplated by parties at the time of the treaty was signed. Commercial logging was never a part of that agreement, that treaty. So was not logical evolution. So this is in no way. So last is very, very important. Almost in every question, something or the other relates to duty to consult. Because mostly what happens whenever you're talking about aboriginal title, aboriginal right, then there comes an issue which talks about few changes. So whenever there is a change, there is a duty to consult with aboriginal people whosoever are getting affected with that change. So section 35 not only guarantees existing treaty rights but also impose on government a duty to engage in various processes even before aboriginal treaty right is established. So Section 35 established a special relationship, as I told you earlier, a fiduciary relationship between Crown and Aboriginal people, under which the honor of Crown must govern all dealing. What do we mean by this honor of Crown? So in Haida Nation versus BC, it was cleared out that honor of Crown means there is a duty to negotiate Aboriginal claim with First Nation. So where claims are unresolved, it is the duty of Crown to consult, to necessarily accommodate, to bring into forth the interest of Aboriginal people. So this duty to consult and accommodation of interest were established in Haida Nation case, where the extent of consultation and accommodation is proportionate to preliminary assessment of strength of claim, right or title. So this duty does not extend to private parties, this only extends to Crown. So whenever there is some kind of infringement, interference with Aboriginal rights, title, treaty, whatsoever, if that infringement is going to happen by Crown, by federal government, then it's the duty as per Section 35 on part of Crown to protect its honor, to save this fiduciary relationship, to firstly consult with Aboriginal people affected by those interference. So this duty does not extend to private parties. There is no duty to agree with Aboriginal people after consultation, as confirmed in Taku River Linked First Nation versus BC, where meaningful consultation did not require agreement, accommodation needed a reasonable balance. So after consultation, there is no requirement again to meet indigenous people, to bring their considerations into picture. So whatever things have been decided in the consultation, those are fine. So we are talking about this duty to consult, and for this we will be talking about three things. Firstly, Section 25, that is a protective clause. So Section 25 says that the Charter's interpretation should not be derogatory to any Aboriginal rights or treaty. For example, when we say equality, Section 15 of the Charter, it does not mean that we have to treat everyone equal, and the government cannot enact any law special for indigenous people. Definitely 100% government can, because these are the people who are of little vulnerable nature, who were original occupants and their few rights have been infringed, their lands have been taken away from them, and they faced so many miserable things like the residential schools and things like that. So they need some special treatment, special provision, special kind of protection. So that is under Section 35. So Charter has to be interpreted in such a way that we are trying to reconcile, accommodate the interest of Aboriginal people. So Charter at no stage should be construed, interpreted, applied in derogation to Aboriginal right. So this is what Section 25 says. Then this protection is under Section 35. So 91-24 of Constitution, then 25-35 can be repealed or amended by constitutional amendment using 750 formula. So constitutional amendment can happen, but for that, what's the requirement? Duty to consult. So Aboriginal people's concern that their constitutional protections are still vulnerable. So Section 35.1 was added, declaring that federal and provincial government are committed to principle that before any amendment is made, a constitutional conference will be convened. What does this mean? This conference means duty to consult. A proper negotiation will be there. They will sit together and then they will discuss that, okay, we are going to make this change. Then the Crown, the federal government, the provincial government will ask for their opinion, and if everyone agrees, only then they can make the amendment. Then the Charlottetown Accord. Although this accord was defeated in a referendum, it will still have lasting effect. The leaders of 4 national Aboriginal organizations along with 11 First Nation ministers, 2 territorial leaders were full parties to all discussions that led to this accord. So Aboriginal participation was not only confined to Aboriginal provision. The agreement by all First Ministers that Aboriginal people have inherent right to self-government should be regarded as an informal recognition that their rights do exist even now. So government should continue to negotiate to come up with self-government agreement. So this thing, duty to consult, negotiation, is nothing new. Even before 1982, when we have this Charlton Accord, that also recognize, that also time and again bring forth the ideas, the consultation, the opinions of Aboriginal minister. So now comes landmark case on duty to consult, Haida Nation versus BC 2004. So duty to consult and accommodate arise from honor of crown. It's the crown's duty. Crown has knowledge of potential Aboriginal right or title and contemplate conduct that might adversely affect them. So when Crown has knowledge, so this knowledge word is important, then it becomes duty of Crown to consult people who are going to be affected by that change. Scope of duty is proportionate to strength of the case, supporting the existence of right or title. Amendment of Crown policy may lead to accommodation. So you have to accommodate all those people from the Aboriginal community who are important to include in such discussion consultation. Third parties do not owe such a duty, only Crown. Both provincial federal government are subject to this duty. There is no duty for government to agree. So it's not mandatory that government should agree. They must bring forth their interest, their Aboriginal people interest, they consult, they negotiate. Government holds legal title to land and granted warehouses the right to harvest forests subject to the land claimed by Haida people. So there was a land and government gave a company legal rights to harvest such forests that were under the land by Haida people. So is the government required to consult with Haida people about decision to harvest forest and accommodate concern before they prove their title to the land? So duty is grounded in the honor of crown and implied by section 35. So all these things which we talked about earlier under ratio. So there is no duty to agree, but as I told you, negotiation, meaningful consultation is required. Duty arises when Crown has knowledge that there are some right or title exist that might affect indigenous people. So duty is to maintain the honor of the Crown and reconcile with Aboriginal people. So Supreme Court sets out in this case that 100% a duty to consult exists. The Crown honor and goal of reconciliation suggests that a duty arises where the Crown has knowledge, real or constructive, indirectly or directly, of the potential existence of Aboriginal right or title and contemplates conduct that and is going to do something that might adversely affect those people's right. Another question is, do third parties owe a duty? The answer is no, only Crown. Crown is responsible for actions affecting Aboriginal interest. The Crown also must engage in meaningful and good faith. If there is some private party that is infringing Aboriginal right, then there is separate issue. Then the Aboriginal people can fight a case before the court. Here we are only talking about federal government's duty that is mandatory in nature. We are not here concerned about the private party, third party rights. Province, definitely provincial and federal government both are subject to this duty. So that was all about today's important lecture. Thank you and good luck.